All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. This is the time set for oral argument in South Point Energy Center, LLC versus the Arizona Department of Revenue. ART, case number 1CA TX20-004. Counsel, we have read the briefs in this matter. We've discussed this matter in conference this morning. I will let you know that Judge Williams is unable to attend today on a personal matter, but he is watching these proceedings via live stream. If he has any questions, he's going to email them to Judge Bailey. And so if we ask you a question late in the argument and you're wondering, where did that come from? You'll know it came from a greater source, and we'll proceed in that manner. As I indicated, we are live streaming this and recording it. So when you stand at the podium and you announce, would you please announce who you represent, who you are and who you represent? And the appellant, I would remind you that you can reserve the amount of time you want, but you are responsible for that. And with that, we will proceed.
And I'm going to do something rude right from the start. I'm going to ask you a question. Procedurally, when I errantly authored the first opinion in this case, we had said that in order to do a Bracker analysis that we were going to remand for Whiteco findings, which is what you had urged in the original opening brief, was that there was a violation of party presentation, that nobody was allowed to really, that the facts were in the record, but nobody had been allowed. You were supposed to be doing this on third motion for summary judgment. I'm surmising that this issue wasn't raised in the petition for review, that it could be that the Supreme Court had no idea what this Whiteco thing was or that it was needed. And so when we get a remand that says analyze for Bracker, which you didn't do, are we still in the same position where we need to remand to the tax court to do a Whiteco analysis?
No, Your Honor. First, let me state for the recording purposes.
Oh, sorry, I didn't even let you announce.
My name is Cooper, and as before, I represent South Point Energy Center, and we did very much appreciate your prior opinion. I think the answer is Whiteco is still not necessary for this record. The court had remanded for Whiteco because the categorical preemption that the court had recognized only applied to permanent improvements. So it was necessary at that point to divide out what was personal permanent improvements from what was personal property, and that's what Whiteco was about. The Bracker analysis would apply to both permanent improvements and to property taxes on personal property. So for this issue before the court today, one doesn't need discovery on the Whiteco factors.
Do we need to make determination at
No.
this point about personal versus permanent?
No, because right now the courts, the ground of preemption doesn't change regardless of whether it's the permanent improvements or it's personal property that's incident to those improvements. The same arguments would apply to Bracker analysis in both. So the court doesn't need a factual analysis at this point of the Whiteco factors. It may become necessary later, but it doesn't right now, because right now we're still asking whether or not there's preemption at play.
Why could they become relevant later then? What
If-
determination would we make where Whiteco would become relevant?
I don't believe it would be on Bracker analysis because it could apply to both personal property and permanent improvements. But if the court were to say, well, this analysis only yields preemption as to permanent improvements, at that point one would remand to the tax court, as one would in any case, to make a determination about what's permanent improvements, what's personal property.
Oh, so you're saying if just so I understand your argument, because it wasn't raised in the supplemental briefing, or wasn't it?
It
Right?
wasn't. I don't think
Okay,
either side thought it was necessary at this point.
Okay, so if we determine that it's not preempted, that's the end.
Correct.
If we determine it is preempted, we would say it's preempted towards permanent, or
Well, we would say it was preempted as to all.
Okay.
And so therefore you would need white cofactors. It only becomes relevant if the preemption is only as to the permanent improvements, and then you have to divide out what's permanent improvement, what's personal.
But nobody's asked us in a Bracker analysis to say it only applies to permanent or it applies to both. I mean, that's not in anyone's briefing either.
Correct.
So how would we?
I don't, Your Honor, I don't think you do get into that question for
Okay.
purposes of Bracker analysis, but
Okay.
if the court decided, in its, after reviewing the case that it needed to go there, that's when it would have to remand for white co-analysis. But I don't think either side has suggested that that's relevant to this issue.
Okay. We'll wait for the
Yeah.
department to tell us their position, but
Okay.
your position is the preemption, just so I'm clear, the preemption argument is it's either all or nothing.
Yes, and that's different from the other ground of preemption, which was only as to permanent improvement.
Okay, thank you. Sorry.
We're happy to say that Bracker balancing test is alive and well in tax cases. And if ever there were a case where Bracker would yield preemption, it is this case, both because of the nature of the ad valorem property tax and the facts of record. The other cases one get are not even property taxes. They are taxes on individuals, people, companies. They are income taxes. They are possessory interest taxes, which fall on the individual, not on the property, or they are transaction privilege taxes. The fact is, state and local governments do not attempt what the county did here, which is to impose an ad valorem property tax on the property itself. And that's because, unlike transaction privilege taxes or possessor income taxes or sales taxes or anything like that, the ad valorem property tax is on the property itself. It's not on the non-Indian owner of the property. The tax is owed by the property, not by the non-owner's personal obligation. And that's clear under Arizona law. The only way to enforce this tax is by putting a lien under Arizona statutes on the permanent improvements, on the property itself, and on the underlying land.
And has the lease, though, contemplated the fact that if the state were to impose property taxes, that the tribe was going to reimburse South Point? Didn't you guys contract that away as far as where the incident of the tax falls?
Well, the incidence of the tax, the legal incidence of the tax, is on the property itself. The economic burden falls on both, because the record indicates that when the tribe took into account the tax burden on us on fixing their own amounts.
Right.
And that was clear under the prior leases. And then under the 2012 revised lease, they wrapped all the tax payments, all of the lease payments, everything into a lump sum of $27 million and then $18 million over approximately a 10-year period. So all that got factored in. And the test for economic burden on a tribe is not whether there's a reimbursement, but because here the uncontradicted evidence is that that the concern about double taxation went into the lease arrangements between the tribe and SPEC, as with other entities, because the tribal law authorized partial or total exemptions, that authorized trade-offs, because the tribe was specifically concerned about the burden of double taxation. So it's factored in because they didn't go for a tax payment because the tribe wanted the money up front so it could fund capital development on the reservation and retire its debt.
But the cases don't tell us that just because the tribe has an additional expense or because the tribe may have to account for the fact that the state will tax that property, that may decrease economic development. I mean, none of those things has been preclusive as to a double taxation situation. I understand your argument is not as to property taxes, but that isn't determinative of our analysis.
And we're not suggesting it is. It's one of the factors that gets weighed into the analysis. The Bracker analysis is a factually intensive analysis. And in this case, the facts taken across the board are clear as day.
And what do you
If
think the
look
most
at-
important ones are? Because it looks like from the Bracker cases, it's all over the board. I mean, you can justify the result looking back at their analysis, but you just as easily could have gone the other way if you put those facts into a different case. So what do you think the most important parts of Bracker are that weigh for South Point?
A couple of them. First, the nature of the tax. It's a tax on the property affixed to the land. And this is property, the facility, that the tribe has an option to retain the facility after the expiration of the lease. This is not like taxing the non-Indians themselves. The obligation runs onto the land. Secondly, the state, this is a unique case that the state and local governments do absolutely nothing for the taxed property, that is the facility.
Well, that's not their argument. I mean, they
Well-
have a list of things that they believe.
Well, actually, and I'll get to those couple. The first thing is, I think, a legal error by the department and the county in their brief, and that's the misreading of Cotton Petroleum. When they quote from Cotton Petroleum that you count all of the benefits to the tribal members as well as the facilities,
Right.
that's not the Bracker section of Cotton Petroleum. That's a separate challenge in Part 4 of the opinion, dealing with whether it violates the Interstate Commerce Clause because there's no allocation or apportionment among separate sovereigns that are imposing taxes. That's what that is about. That's got nothing to do with Bracker.
The ultimate holding in Cotton was that you can have dual taxation between.
You can, and they said there was no preemption in Cotton Petroleum because the state had provided services to what was being taxed. That was the severance tax on oil and gas wells, and the state directly regulated the spacing and mechanical integrity of those wells, and it was about $90,000 worth of services. And the court just said, we're not going to ask whether the value of those services,
It's proportional.
justified the value
Right.
of the tax, but it recognized that there were services. Here, the remarkable thing is the department admitted in the tax court, both, that the state and local governments had no regulatory authority over SPC or the tribe or the facility, which that itself distinguishes it from Cotton, where the state regulated the wells that produced the oil and gas. And second, that the department admitted, and the county, that they provide no services to facility. They don't. Now, when we got down to it, what the county and department pointed to in terms of services were things that they were doing anyway that had nothing to do with the facility. So they pointed to schools and community colleges and regional flood control and things like that. That have nothing to do with the facility. They were doing that anyway. None of that has been shown to benefit the facility, except the notion, well, your employees' kids could go to those public schools. That's not what the test is.
And do,
I'm sorry?
correct? And do.
I don't think there's record of how many do, but that's not a benefit of the facility. That's just because people who live on the reservation are American citizens who get to go to public schools. But they also, a lot of them go to tribal schools, so it's not clear what that is. But whatever it has to do, it has nothing to do with the operation of the facility that they're taxing. Now, the interesting one they say is, there are county roads that go outside. And they cite the Ute Mountain, Ute Tribe versus Rodriguez case. But this is distinguishable from that, easily distinguishable, because in Ute Mountain, which dealt with the severance tax on oil and gas, the court pointed to the fact that those state roads were critical to the operation of the severance because they were the infrastructure that allowed you to take the oil and gas off the reservation and to get it to market. This case is the opposite of Ute because nothing relating to the facility goes over those roads. Nothing. The federal rights-of-way over BLM land have the natural gas pipelines that deliver to the facility. The federally owned transmission lines go over federal BLM right-of-ways to take the electricity out to wheel it into the interstate grid. None of this goes over that road. None of it goes over state or local property. It goes from the reservation onto federally owned land out into federal instrumentalities. It has nothing to do with it. In fact, if this case isn't even like the transaction privilege tax cases having to do with Scottsdale Pavilions or Compton Terrace, because there the court said, we've got police regulating, we've got doing traffic control for events, the state built an off-ramp off of the 101 to go to Scottsdale Pavilions. The city of Scottsdale provides fire services. None of that is true here because the public doesn't come to the facility. There are no customers who do not come to the facility. No one comes to facilities. And if they do, they don't come by that road. They come from Las Vegas, from McCarran Airport, from the Nevada side. So, it's nice. It's hard to find a reservation anywhere in the United States that doesn't have some road leading up to it.
So if we're setting aside federal regulation and the BIA's interpretation of those regulations, if we're setting all that aside, as the state argues, what is the federal law that we should consider?
Easy. We cited in our brief, our supplemental brief at page 30. We cited the federal statutes authorizing all that regulatory control, and that's 25 U.S.C. sections 415 to 416J. That's cited in our brief. So when the defendant said, we never cited any statute, that's simply not true. And all of that's in the Seminole Indian Tribe versus Stromberg case from the 11th Circuit, which is dealing with the whole statutory and regulatory framework. I think it's also important to note, this is like Stromberg. Stromberg said, the 11th Circuit said, that the BIA does not have the authority to preempt taxes itself. We never said that it did. What we're saying, the 11th Circuit looked to the regulations or the prefaces to say this is evidence of the federal interests in this property. Not that the regulations directly preempt, but that they establish what the federal interests are. And it's those interests that in BRCA analysis outweigh any interest of the state or local.
Would that apply, though, to just about any scenario if you're going to call it something so general? A federal interest in?
Well, there's a specific interest in the development of land. This is not implicated where you're taxing cigarette sales or anything else. That's not. This is a power generation facility where the Department of Energy and WAPA and the BIA said in approving the lease, they said this lease is an exercise of the tribe's self-determination. This is a critical project, and it involves the use of the tribal land. It's very different from just a transaction privilege tax that's imposed on non-Indian owners, and that's what the BIA talks about in the hearings and in the regulatory preface.
Comments to the regulations, right?
They're talking about that when you're dealing with leasing for permanent improvements, the federal interests are at their maximum in the scale, in the weighing of these interests, and that the BIA.
But my question is, wouldn't that preempt just about everything? Because you could always make an argument that it's for the economic development of the tribe. I mean, the whole system we've set out is so the tribe can maximize economic potential of the resources that it has. So your test seems like it would preempt everything.
It wouldn't, because there's a general recognition, I think, that it would not preempt the possessory interest tax that was imposed on the individual lessees. But Arizona stopped taxing possessory interests in 20 years ago. Arizona chooses not to do it. California does this by taxing possessory interests. But the Arizona in this case and the county have chosen particularly the worst kind of tax to try to impose on a development of an Indian reservation, which is an ad valorem property tax. You can do TPT, you can do income taxes, which they do, you can do possessory income taxes. That's Arizona's choice. But the method they've undertaken here raises interests that are unlike those in those other cases because the tax is on the property. It's not on the non-Indians. And that's what makes this case different from all those others, among other things. I'd like to reserve, if I can, the last couple of minutes.
Sounds good.
All right, thank you, Mr. Cooper. We'll now hear from the department.
Good morning. My name's Cameron Artigue, and I'm here for the Arizona Department of Revenue and Mojave County. The problem here is the combination of the breadth of the taxpayer's argument and the ubiquity of ad valorem property taxes. Let me start with the colloquy you had with Mr. Cooper about the reach of the taxpayer's argument. You're exactly correct. The taxpayer is making the identical argument that the tax is preempted as to personal property exactly the same way as it's preempted as to permanent improvements. This demonstrates the untenable reach of the taxpayer's argument, because what it means is that anybody can go park their personal property, their construction equipment, their inventory on a tribal reservation, and that becomes a tax-free zone. That is not just the implication of the argument, that is the argument. And the reach of the taxpayer's argument is its fatal flaw.
So,
Go ahead.
since you're drawing a distinction between permanent and temporary, have we had a factual determination in the tax court on that issue? Isn't there a Whiteco issue involved?
Well, I don't think there's a Whiteco issue because it's my client's position that the tax, both are taxable. And I don't think it's incumbent on this court to make arguments that the taxpayer has not made, to draw a distinction that the taxpayer has not advocated. And the department does not advocate any such distinction. So I don't think a remand for Whiteco findings is necessary.
Mr. Cooper said that if we determine that that does make a difference in looking at the case, sorting through these cases, that then perhaps it would be required. But the position is they don't believe it does. But if we believe it does, then it comes back to my question, is that should we have to remand for a Whiteco?
As a logical matter, yes, Judge. If this court so determined, that would logically suggest a remand.
What if we so determined what? What would we have to say?
Well, what you'd have to say is that this is the first, that taxes on some aspect of the taxpayer's property are preempted. Now, it is the department...
Well, is it more narrow than that? We would simply say, in going through these cases, permanent improvements are exempt.
Well, but that's not... You could say that, but this would be the first case in the history of jurisprudence so to hold. There is no case holding that an ad valorem property tax, whether it's on permanent improvements or personal property, is preempted. We are 42 years into the Bracker era,
Okay.
and there's no such precedent.
So if we say that there is no preemption, as Judge McMurray asked Mr. Cooper, then Whiteco's out. We say there's no preemption, you get the tax, it doesn't matter what, go do your thing and be taxed.
Agreed.
If we say, what would we have to say we need to remand for Whiteco, or we need to, what would our holding have to be that would implicate Whiteco?
I think your holding would have to be that you are going to draw a distinction on behalf of the taxpayer that the taxpayer has not advocated to the court. That you would have to sort of say, well, this wasn't in the supplemental briefs, and the taxpayer hasn't made any such argument, but we see some sort of distinction, and depending on what this court perceived, maybe remand for Whiteco findings would be appropriate.
But they did raise it in their OB the first time around, and both of your supplemental briefs, because it's fun to have to go back and read everything and not just have everything in one place, said, oh no, we incorporate by reference everything we've already said, which they did raise, and you responded to, and they said, listen, the court said permanent improvement, they shouldn't have done that, and therefore we don't know what's what, and you have to send it back to say something.
Right. The Whiteco issue came up under the aegis of the Indian Reorganization Act per se argument that the Supreme Court reversed on. If you look back at all this corpus of Bracker jurisprudence, you will not see that Whiteco case cited, ever. It's a tax case.
And yet the tax court without objection said, I'm going to do 3 rounds of motions for summary judgment in this case. You're going to brief this, then Bracker, then Whiteco. You were on track to do that for a reason that I assume the litigants felt was important at the time in front of the tax court. And part of the complaint was you never let us get to the point where we argued that, and therefore there's error in making any kind of Bracker conclusions without determining what's permanent and what's... And I just want to make sure that we're dealing with that if we should, even though no one talked to the Supreme Court, no one's raised it in supplemental briefing, I'm not sure it's waived when you've incorporated by reference everything you've said in this case.
No, I don't think it's been waived, Your Honor. I think, though, that I think it is procedurally permissible for this court to affirm the tax court's judgment. The tax court decided all issues on the merits, and the appellant has not argued to this court that the failure to make the Whiteco findings with respect to the Bracker issue was error. That is not a submission of error that's been made here. So
I guess I'll ask Mr. Cooper about that, because it sure feels like in their OB starting about page 24 that they're making just that argument.
Well, if this court determines that there's a basis that the tax may be preempted with respect to some property and not others, then, as I said to Judge McMurdy, yes, then a remand would logically follow from that. I'm here to advocate that this ought not be the first case ever to hold that an ad valorem property tax is preempted. There is a history both before Bracker.
I realize it might not be an ad valorem ad valorem tax, but didn't the Ninth Circuit in Confederated Tribes versus Thurston barred property taxes on a permanent improvement?
That was under the Indian Reorganization Act, and it was tribal property because it was 51% owned by the Native American corporation. This is non-Indian property. That's the point.
In reading that case, though, it does seem like there's some language that would lend itself to the fact that permanent improvements are different.
Permanent improvements owned by an Indian tribe, to be sure. Yes.
But wait a minute. Didn't you just say that it doesn't that turn on whether this are permanent improvements?
No, all property of an Indian tribe, whether it's personal property or real estate or permanent improvements, is exempt. The Chehalis case was interesting because it involved a hotel that was a joint venture between the Indian tribe and a non-Indian entity. It was majority owned by the Indian tribe. And in that...
By an Indian tribe's LLC.
Right. That's correct. But sovereign immunity equates the two, the tribal sovereign with their corporate functionaries. But that context is different than here you have South Point Energy Center. It's a non-Indian entity. There's no tribal ownership in it. Mr. Cooper says, well, the tax is on the property. Yes, it's on non-Indian property, just like a tax on any railroad or any utility pipeline or any of the stuff you see when you drive on the 101 in Scottsdale. You know, that is not tribal property. The real estate is, but that's not being taxed. The improvements, if they are non-Indian owned, are taxable.
And what about what happens with the carrying it out to the fact that it doesn't get paid, there's a lien on it? What's that doomsday scenario? What's your answer to that?
I would direct you to this court's decision in Comalco versus Maricopa County by Judge Tosi in 1997, in which he said that is irrelevant, that because there's a hypothetical enforcement scenario that would involve a violation of federal law is meaningless. You can enforce this as a money judgment. And frankly, if no one wants to bid on a turbine that's attached to reservation land at a tax lien sale, that's kind of the Department of Revenue's problem.
Yeah, but I think their point is that what if someone does? I mean, what if someone does and that they haven't gone through the structures that South Point had to go through to have a lease with the BIA and to be approved?
Well, then we have an interesting case, Judge. You know, if anytime, if I buy a tax lien on a truck and try and say I'm going to go on the reservation now and take possession of the truck that I bought at the tax sale, and the tribal police say you're not allowed on the reservation, get off. That's an interesting case. I don't know how that works out.
Well, I think what they're saying is that means the incident of the tax really falls on the tribe because the structure on their land is somehow, I don't know whether it's that it's going to be interesting later as much as it is a point to prove that the incidence of the tax falls on the tribe because they're left to deal with it.
Well, the incidence of the tax falls on the tribe is not Mr. Cooper's argument. He says the incidence of the tax is on the property. And my point is exactly right. It's non-Indian property. It's an ad valorem property tax. And under the cases that go back 100 years You can tax the railroads and the pipelines and the utility transmission lines. And the Supreme Court says in Cotton Petroleum, they say, of course, that when you put a state tax into the mix, it probably reduces the economic equation for
and
tribes
that's of
leasing
no
the property.
consequence
But that's
because it always
indirect
will.
and I cut you off, I'm sorry.
No, I'm saying I get it. They say that's always going to be the case, and that can't be determinative.
Right. And here you have the tribe. The quote-unquote impact on the Fort Mojave Indian tribe is a resolution that says, well, this probably is going to harm us in the future. And you can't have a dog in this fight by saying, well, I may have it. My dog in this fight is that I'll have a dog in the next fight. That's not that's not enough. Let me say something about the state of Arizona's benefits here. This is, the test is complete abdication. The record shows that Mojave County treats this as an integrated, homogenized portion of Mojave County, okay? The children go to Mojave County schools, the tribal members. Footnote 7 of the Cotton Petroleum case is the findings of the district court in that case, that the relevant services are the services rendered to the tribe itself and tribal members on the reservation and tribal members off the reservation.
Right.
Footnote 7 is again cited at page 185 of the Supreme Court opinion, which is not the part Mr. Cooper's talking about, where they say, yeah, there's no abdication here. New Mexico is providing services to the taxpayer and the tribal community. Arizona does that. Mojave Route 1, this is judicial notice. Go look at it on Google Earth. You cannot get to this facility unless you drive on Courtright Road, Mojave Route 1. It's the only way in. It's the only way out.
So you can't get in from another state road?
No, well, Mr. Cooper says, people fly into McCarran Airport. Well, sure. Las Vegas is 17 miles away. I mean, Nevada is 17 miles away. I did that this morning. You have to drive on Courtright Road, Mojave Route there to get there. The natural gas may come through a pipeline, but the workers,
They can't get there through Nevada, through California, through anywhere else. They have to go through.
It's in Mojave County.
Okay.
You can't, unless you jump from the river, you can't get there unless you drive on a Mojave County road.
Okay.
And the rest of it, all the recorder and the police and the fire and the floodplain delineation, all the stuff that is the run-of-the-mill county services that everybody in Mojave County gets is also supplied.
And their response would be, that's the same in that could be a very similar situation to any other incident where there's a county that abuts a tribe or includes a tribe that also provides these kind of ancillary services that would always be provided. So why is that enough of an argument for us that weighs into BRAC, or that I understand it's not proportional?
No, it's not proportional. It's because it's not abdication. Abdication means you're not doing that which you're supposed to do. What the Supreme Court says in Cotton Petroleum is, well, BRAC involved abdication because the state just kind of no-showed on this Indian community. And that could happen with the geography of, say, the Navajo Nation, where you've got talking about vast distances. If you look at a map, this is like a checkerboard. This is square miles of tribal land integrated into an urbanized area. And you couldn't cut it, you couldn't separate it from the surrounding community unless you built roads that are less than a mile long. So this is the paradigm example of what it means to not abdicate. When you're educating the local tribal children, that's the ballgame. I mean, that's not abdicating. That's educating the local tribal children. The tribal interest here, as I said, is that, well, maybe in the future this will damage us. The record shows that this tribe was bought out. They received a $27 million lump sum payment in 2012 and $2 million a year through 2021. The tribe's done. If the tribe had an interest in this lawsuit, they would be here in this courtroom. they would be here with that kind of money in play. And what the tribe has done in this case is sign off on a custodian of records affidavit saying, yeah, here's our records. And, oh yeah, there's a resolution that maybe in the future this would have some impact to us. That's not the grist for the first case in the history of federal Indian law to strike down an ad valorem property tax. This is, if you had to say, hey, what is an easy hypothetical in a course on federal Indian law, this is an easy hypothetical. Where the tribe's interest is zero.
Well, you keep saying that this would be the first case, but what case do you have specifically that would say it doesn't apply to an ad valorem tax?
The Navajo County versus Peabody Coal case in 1977, cited on page 6 of our opening brief, where the Peabody Coal Company says, well, of course Navajo County can tax our improvements. Now that's pre-Bracker. That's 1977. But post-Bracker, in footnote 2 of our supplemental brief, we cite 3 cases decided post-Bracker. There's a 1989 case from Montana. There's a 2020 case from Pickerel Lake. It's one of the Dakotas. Where they go through all the Bracker and they say, yeah, of course, consistent with the historic non-Indian lessee cases that have been around since the 1800s, states can impose property taxes on non-tribal property. That's why this taxpayer spent the first 8 years of this long battle fighting over who owned the property. I mean, this court's opinion from 2009 says, the central issue in this whole dispute is who owns the power plant. And who owns it is South Point Energy Center. And then they went to the next fallback. And now we're on the third fallback. And we're on the third fallback because it's weaker than the first two. And that is why this court should resist the invitation to create new law by saying that an ad valorem property tax is preempted. Unless you have questions, I'm going to sit down.
Okay. Do you have any questions? No. All right. Thank you.
Thank you.
All right, Mr. Cooper,
Your
any
Honor,
final
with
words?
all respect, I try to maintain a poker face, but Mr. Artigue just wrote a lot of checks that the facts in the law do not cash. First of all, Cotton Petroleum, his footnote 7, that was not in the Bracker analysis. That was in the factual recounting of the case. When the court got to the Bracker analysis, it looked only to the fact that the state provided regulation for the oil and gas wells, the mechanical integrity and the spacing of the wells. It did not look. All that other stuff came in under the Interstate Commerce Clause analysis. That's where footnote 7 is. It's not in the Bracker analysis. It's part 1 of the opinion. Pamalco was a possessory interest tax on the leasehold interest. It was not an ad valorem property tax. Arizona doesn't impose possessory interest taxes anymore. Navajo coal, as we've said incessantly, the court said the issue of preemption is not presented to the court and we don't decide it. So, you can't keep misciting cases and then come back and reassert the same things. Now, about the court is absolutely right. There is no case upholding this tax, ad valorem property tax under Bracker, because no one tries to do this except for the county in this case. Every other state tries to do possessory interest taxes, if you look at them. They are not about, and the Pickerel Lake case says, no one urged Bracker analysis on us. So that's not even a Bracker case. That was a categorical preemption case. It simply does not apply. As far as bulldozers, we're not claiming this is a tax-free zone where you can park your car and escape taxes. Any personal property, it's probably pretty small, desks, maybe a couple of laptops, is incident to the operation of a 500 megawatt combined cycle natural gas power plant that wheels power to the interstate grid. Okay, there is no bulldozer being parked. No one is using this as a zone. As far as the lien enforcement, this goes to the inherent nature. The lien is not just on the property. The lien goes under Arizona law to the real property itself. That means to the tribal land. And so it's not just about unenforceability. It's obnoxious to federal law and to tribal sovereignty even to have the lien on it. That's not Pamalco. Pamalco was a possessory interest tax. It's just the notion that Mojave County treats this as, I believe his phrase was, an integrated and homogenized part of the reservation, it may be part of a checkerboard, but the square therein is not part of the checkerboard. It adjoins federal land. That's how the electricity goes out and the gas comes in and the water comes in from the tribe's allotment.
All right, thank you, Mr. Cooper. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your briefing and your argument. Court's in recess.